Trust tax go down. Trust tax go down.
Yo, Mr. Smith, you're here to contest the county's tax on that property address. It's held in a trust, private and lien. No business, no state ties in between. Yes, Your Honor, that's my scene. This property's private, if you know what I mean. No minimum contacts, it don't mess with the state. Just chillin' for beneficiaries, no tax on the plate. Minimum contacts, but that's for real. The county says property tax is a bill. They claim location sets jurisdiction tight. Doesn't matter if it's trust or spotlight. Respectfully, Judge, let me take it back. International shoe set that contact track. In Schaffer v. Heitner, it came through. Location ain't all if contacts are few. Alright, I see, you're throwing down law with precedent sharp like a courtroom saw. But if it's in the county, do the taxes apply? Mr. Carter, county's lawyer, you wanna try? Thank you, Judge, for letting me drop. This property benefits from state-built props. Roads, emergency lights, and the law. Even if passive, they get it all. Mr. Smith, can you come back strong? They say even passive, the benefits are on. Your Honor, they got it wrong. Quill Corp, North Dakota says it's not that long. Trust don't need roads or emergency play. Purely private just keeps taxes away. Alright, Mr. Carter's got notes, but Smith brought more and Heitner quotes. Minimum contacts, non-commercial too. Could this trust slip right through? OCG, a 4853, all properties taxed, ain't that clear to see? Doesn't matter if it's trust, personal, or court. Every property's subject to the tax report. Smith, you got one more to lay? Why should a trust get a tax-free stay? It's in the statutes, Your Honor, no bluff. More the US says private trust stuff. Held with the beneficiaries quiet and still. No commercial use, just private chill. I've heard the case from both sides spun. Each point made, each legal gun. I'm granting a break from the county's demand until they get a clearer hand. We still say this property benefits all. Infrastructure's here, just one call. Property tax keeps the whole county strong. Equal share, everyone along. But minimum contacts can't be denied. Non-commercial trust on the private side. Smith, you got a temporary win. Suspended taxes till county brings it again.
Trust tax go down. Trust tax go down. Trust tax go down. Trust tax go down.
Alright, here's the final word. Private trust in this court has been heard. No tax on trust held without a fee, as long as it's private and commerce free. Case dismissed, bring in that gavel's might. Private trust properties out of sight. Court adjourned, go ahead and sign. Trust tax throwdown, verdict's mine.
Challenging property tax on private express trusts, a courtroom dialogue on jurisdiction, minimum contacts, and tax exemption. Mr. Smith, I understand you are here to contest the county's property tax assessments on a property held in a private express trust. Can you explain in your own words the basis of your challenge? Accused. Yes, Your Honor. The property in question is held in a private express trust, established for the sole benefit of the trust's beneficiaries, without any commercial activity or state benefits, meaning it lacks minimum contacts with the state necessary to justify taxation. Minimum contacts, you say? Could you clarify how that principle applies to property tax specifically? The county asserts that all property, whether personal or held in trust, is subject to local taxation. Accused. Certainly, Your Honor. The principle of minimum contacts was established in International Shoe Cove, Washington, where the Supreme Court held that a state can only exercise jurisdiction if there are substantial connections to the state. This property is purely private and non-commercial. It doesn't rely on state services or engage in any activities that would establish taxable contacts. But Mr. Smith, isn't the property physically located within the county? Doesn't that location alone create a jurisdictional basis for taxation? Accused, respectfully, Your Honor, mere location within the state does not automatically confer tax jurisdiction. In Schaffer v. Heitner, the court decided that simply owning property in a state does not establish jurisdiction if there is no purposeful availment of state laws. Since the trust property is not used commercially and doesn't benefit from county services, it should not be subject to taxation. Judge, I see. Now you've also filed a writ of quo warranto requesting the county justify its authority to tax the property in trust. Could you explain the purpose of this writ and why you believe it applies here? Accused, yes, Your Honor. The writ of quo warranto is intended to challenge the county's authority by requiring it to demonstrate its lawful basis for these assessments. Since the property is held privately and without commercial use, the county has yet to prove that it has the jurisdiction to impose taxes on the trust property. Interesting. And I see you've also referenced Georgia state statutes. Are you arguing that state law excludes trust property from property tax? Accused, in part, Your Honor. Georgia's Trust Code, OCGA, Tiger 5312-20, defines trusts in a way that typically exempts non-commercial assets held solely for private benefit from tax obligations. This property, held purely for the trust's beneficiaries, does not engage in activities that would warrant inclusion under taxable property definitions in the state. Thank you, Mr. Smith. Your arguments raise valid questions about the scope of property tax jurisdiction over private express trusts. I'll need to review the legal precedents and statutory definitions you've referenced, as well as the county's response to your writ of quo warranto. Accused. Thank you, Your Honor. I believe the law supports the exemption of private trust property from local taxation where it lacks taxable contacts and state benefits. Judge, noted. I'll take all of this into consideration and issue a ruling after further review. We'll reconvene once I have assessed the arguments and applicable law. Court is adjourned. The court is reconvened and the judge enters the courtroom. Court is now in session. After careful review of the arguments and relevant case law, I'd like to address a few points raised in the previous proceeding regarding the county's authority to tax property held in a private express trust. Before I proceed, Mr. Carter, representing the county, I understand you have additional comments in response to the accused's arguments. Please proceed. Thank you, Your Honor. The county maintains that all property physically located within its jurisdiction is subject to local property tax. We argue that regardless of how the property is held, whether by an individual or in a trust, it derives benefit from state infrastructure and services, which warrants taxation. Judge, Mr. Carter, the accused referenced Schaffer v. Heitner and International Shoe Co. v. Washington to argue that minimum contacts are required for the county to impose jurisdiction. How do you respond to the argument that the trust property lacks substantial contacts with the state due to its private, non-commercial nature? Your Honor, we contend that the property's physical presence within the county suffices for tax jurisdiction. The trust may not be commercial, but roads, emergency services, and other public resources are still available to it. In Quill Corp. v. North Dakota, physical presence has often been deemed enough to justify a state's jurisdiction in taxing matters, especially where the property benefits from state services. 1. Turning to the accused. Mr. Smith, would you like to respond to the county's argument regarding the benefits your trust property allegedly receives from state services? Accused. Yes, Your Honor, with respect, the trust property's use is solely for the beneficiary's private enjoyment, and it does not actively engage with or rely on county services. Furthermore, I would argue that Quill Corp. Applies primarily to business activities with clear economic presence. This property, by contrast, does not produce income, nor does it benefit directly from county infrastructure in a way that would justify taxation. But Mr. Smith, how would you counter the argument that even passive benefits, such as the availability of emergency services, might justify a tax assessment? Accused, Your Honor, while the trust property may be located within the county's boundaries, it has not actively engaged with these services, nor availed itself of state benefits. Case law like Moore UX v. United States emphasizes that property held privately and solely for beneficiaries without commercial purpose may retain tax immunities precisely because it lacks substantial engagement with state infrastructure. I understand. Mr. Carter, does the county have any evidence showing active use of state services by the trust property or reliance on county infrastructure that would strengthen your jurisdictional argument? No direct evidence of usage, Your Honor, as the property hasn't specifically required services beyond what's generally available. However, the county argues that the availability of these services creates a potential benefit, which is sufficient to warrant taxation under state statutes. Thank you, Mr. Carter. Mr. Smith, I also see you filed a plea in abatement requesting that further tax demands be suspended until the county proves its jurisdiction. Do you wish to add anything regarding this plea? Accused, yes, Your Honor. By filing this plea in abatement, I request that any further tax assessment be paused until the county can clearly demonstrate jurisdiction, particularly since the trust property's non-commercial nature places it outside typical taxable categories. Without lawful jurisdiction, I argue that these assessments constitute an overreach. I understand. This court finds that your arguments regarding minimum contacts and the non-commercial nature of the property have merit, especially considering the distinct structure of a private express trust. However, as the county argues the presence of general benefits like infrastructure availability, we are facing nuanced legal questions that may not have direct precedent in this jurisdiction. Judge takes a pause, reviewing notes. Here is my ruling. I am granting a temporary suspension of further tax demands on the trust property until the county provides clear statutory or legal justification establishing jurisdiction specifically for private, non-commercial trust properties. Mr. Carter, the county has 60 days to either submit such justification or withdraw the assessment. Additionally, I advise both parties to review relevant state statutes and prepare further arguments if the county chooses to maintain the assessment. County Attorney, understood, Your Honor. Accused, thank you, Your Honor. Judge, this matter is adjourned until further notice, pending the county's response. End of proceedings. Footnotes. 1. Quill Corp. vs. North Dakota, 504 U.S. 2198, 1992. The court is reconvened for the third proceeding. The judge enters the courtroom. Court is now in session. We are here to review the county's response to the plea in abatement and the property tax assessment on a private express trust property, as well as any final arguments from both parties. Mr. Carter, I see the county has submitted further justification. Please summarize your argument. Thank you, Your Honor. In response to the court's order, the county reviewed Georgia property tax statutes and argues that state law grants authority to assess taxes on all properties within its jurisdiction, regardless of their use or ownership structure. According to OCGA, JIR 4853, all real property within the state is subject to taxation unless explicitly exempted by Law 1. The county contends that this property, although held in trust, has not been legally exempted under Georgia statutes. Judge, so the county's position is that the general tax code applies to all properties, including those in private trusts, unless there is a specific exemption. Mr. Smith, how do you respond to this argument? Accused, Your Honor, while I acknowledge that OCGA 4853 covers general property tax obligations, I maintain that this trust property qualifies as an exception under both constitutional principles and the common law understanding of private express trusts. I respectfully argue that the property's structure as a non-commercial private trust limits the state's jurisdiction in the absence of commercial engagement or minimum contacts. You're suggesting that private express trusts, due to their structure, inherently lack the contacts necessary for taxation. However, Mr. Carter argues that the law doesn't recognize such distinctions unless specifically exempted. Do you have legal precedents that directly support the trust's immunity from taxation based solely on its private nature? Accused, yes, Your Honor. I'd like to reference Moore et UX v. United States, where the Supreme Court acknowledged that certain privately held trust properties may be immune from state taxation if they lack commercial purpose too. Additionally, cases such as Schaffer v. Heitner reinforce that physical location alone does not establish jurisdiction without substantial engagement, which our trust property does not demonstrate. Your Honor, with respect to Moore and Schaffer, the county argues these cases primarily involve issues of minimum contacts in interstate commerce or specific jurisdictional questions unrelated to state taxation of real property. The county asserts that Georgia law intends to broadly tax all real property and does not make exceptions for private trusts unless they are clearly exempted, as outlined in OCGA 485-41 for charitable and public purposes 3. Mr. Smith, given this statute, what would you say about the lack of explicit exemption for private express trusts in Georgia law? The statute provides tax exemptions for properties used for public, charitable, or educational purposes, but makes no mention of private trusts. Accused, Your Honor, I believe the court must consider the broader constitutional context. Private property held in trust without commercial use or state benefit shouldn't fall under state tax requirements solely by virtue of location, as per the Privileges and Immunities Clause, which limits states' reach over property with no active engagement. I would argue that the burden is on the county to demonstrate specific authority over private trust property under the state's tax code. Mr. Carter, the accused argues the lack of jurisdictional basis. Does the county have additional evidence that this trust property benefits from state resources or services that could justify taxation? Your Honor, while we don't have direct evidence of service use, we contend that the trust property, like all properties in the county, benefits from the infrastructure and public resources made available through tax revenue. Emergency services, road maintenance, and law enforcement are available to this property should the need arise, and such potential benefit justifies a general tax obligation. Thank you, Mr. Carter. Mr. Smith, any final remarks? Accused, yes, Your Honor. I argue that potential benefit does not equate to direct use or engagement. Since the trust property doesn't actively use these services, imposing a tax lacks a specific justification under the principle of minimum contacts. I respectfully request that the court rule in favor of the plea in abatement, given that the county has not demonstrated sufficient grounds for taxing private trust property that is strictly for private benefit. Thank you both for your well-prepared arguments. Based on the statutes and case law presented, I find this matter complex and without clear precedent in Georgia law. However, I am persuaded that minimum contacts and active benefit are relevant factors in determining tax jurisdiction over trust-held property. After a brief pause, Judge, my ruling is as follows. I will grant the plea in abatement, suspending further tax assessments on the property in question. However, I direct the county to seek further legislative or judicial clarification on the matter, particularly regarding property held in private trusts without commercial use. This court's ruling does not exempt the property indefinitely, but suspends taxation until the county can establish a clear jurisdictional basis or statutory support for such assessments. Accused, thank you, Your Honor. Court is adjourned. End of proceedings. Footnotes 1. OCGA Para 48-5-3, Georgia law mandates taxation on all real property within the state unless specifically exempted by statute. 2. Morat U v. United States, 23 S. Kinhole 440, 2023, recognizes that property held solely for private benefit in a non-commercial trust may, in some cases, retain immunity from taxation. 3. OCGA Prior 48-541 outlines exemptions for properties used for charitable, public, or educational purposes, without mentioning private trusts used exclusively for private benefit. This ruling represents a nuanced interpretation that emphasizes the need for explicit statutory authority for taxing private trust property. The judge's decision suspends taxes on the trust until the county can establish a clear legal basis, illustrating the complexity of property tax jurisdiction over non-commercial private trusts. The court reconvenes for the final proceeding. The judge enters the courtroom. Court is now in session. We are here for the final review of the county's appeal regarding the tax assessment on property held in a private express trust. After examining legislative responses and relevant case law, I am prepared to issue a final ruling. Mr. Carter, representing the county, do you have any final arguments? Thank you, Your Honor. We maintain that under OCGA Te 4853, all property within county lines is subject to taxation unless there is a specific exemption. While we understand the court's previous considerations, we argue that the broad intent of Georgia's property tax statutes covers all real estate, regardless of whether it is held privately or for non-commercial use. 1. Taxation is critical to maintaining county services, which the property could potentially benefit from, even in a non-commercial capacity. I see, Mr. Carter. Your argument is that the mere availability of services, regardless of active use, constitutes sufficient grounds for taxation, correct? Yes, Your Honor. The county relies on the principle that all properties benefit from the broader infrastructure supported by taxes. By taxing all properties equally, we ensure fair distribution of the tax burden across county residents and property holders. Thank you. Mr. Smith, as trustee, you have previously argued that the property's private trust status and lack of minimum contacts with the state exclude it from property tax obligations. Any additional comments before I issue the final ruling? Accused, yes, Your Honor. I would reiterate that this property, held in a private express trust solely for beneficiary use, does not engage in commercial activities or directly utilize state or county resources. While I understand the county's position on potential benefit, the property's actual lack of engagement and active use of county services should exempt it from taxation, as established in cases like Schaffer-Heitner, which emphasize the need for substantial contacts to justify jurisdiction too. The property's private nature aligns with the principles of common law trusts, where private assets solely benefit designated beneficiaries without state intervention. Judge. Both parties have raised compelling arguments throughout this proceeding, and I have carefully reviewed Georgia statutes, constitutional principles, and relevant case law. Here is my final decision. The judge adjusts their glasses and looks at both parties. In consideration of the state's tax authority, the court recognizes the county's need to collect taxes to sustain essential services. However, we also recognize that private property in a trust solely for non-commercial beneficiary use has a unique status that does not neatly fit within general property tax statutes. Georgia law does not specifically exempt private trust property from taxation, nor does it explicitly require taxation of such property absent clear economic benefit or commercial activity. Therefore, I rule as follows. The property held in the private express trust shall remain exempt from county property taxes on the grounds of its non-commercial use and lack of minimum contacts with the state. This exemption applies as long as the property remains within the trust and continues its non-commercial status solely for beneficiary enjoyment. Your Honor, does this ruling set a precedent for other non-commercial private trust properties in the county? This ruling is specific to the facts of this case, Mr. Carter. It applies solely to properties held in private express trusts under similar conditions, namely those without commercial activity, without minimum contacts, and used exclusively for beneficiary purposes. Should the trust's use of the property change, or if the legislature clarifies tax obligations for private trusts, the county may revisit the assessment. Accused. Thank you, Your Honor. This ruling brings necessary clarity for the trust and its beneficiaries. Judge, you're welcome, Mr. Smith. I advise the county to work with the state legislature if it seeks further guidance on similar cases in the future. This ruling is now final and the court is adjourned. The judge bangs the gavel, signaling the end of the proceedings. End of final proceeding. Footnotes 1. OCGA, Pri 48-5-3, Georgia's property tax statute mandating tax collection on all real estate within the state, unless explicitly exempt. 2. Schaffer-Heitner, 433-386, 1977, a Supreme Court case emphasizing the need for minimum contacts for jurisdiction, which has implications for tax assessments on properties without active engagement. In this final ruling, the judge affirms the exemption of the private express trust property from local property taxes due to its private, non-commercial nature of the property have merit, especially considering the distinct structure of a private express trust. However, as the county argues the presence of general benefits like infrastructure availability, we are facing nuanced legal questions that may not have direct precedent in this jurisdiction. Judge takes a pause, reviewing notes. Here is my ruling. I am granting a temporary suspension of further tax demands on the trust property until the county provides clear statutory or legal justification establishing jurisdiction specifically for private, non-commercial trust properties. Mr. Carter, the county has 60 days to either submit such justification or withdraw the assessment. Additionally, I advise both parties to review relevant state statutes and prepare further arguments if the county chooses to maintain the assessment. County Attorney? Understood, Your Honor. Accused? Thank you, Your Honor. Judge, this matter is adjourned until further notice, pending the county's response. End of proceedings. Footnotes. 1. Quill Corp. vs. North Dakota, 504 U.S. 2198, 1992. The court is reconvened for the third proceeding. The judge enters the courtroom. Court is now in session. We are here to review the county's response to the plea in abatement and the property tax assessment on a private express trust property, as well as any final arguments from both parties. Mr. Carter, I see the county has submitted further justification. Please summarize your argument. Thank you, Your Honor. In response to the court's order, the county reviewed Georgia property tax statutes and argues that state law grants authority to assess taxes on all properties within its jurisdiction, regardless of their use or ownership structure. According to OCGA J 4853, all real property within the state is subject to taxation unless explicitly exempted by Law 1. The county contends that this property, although held in trust, has not been legally exempted under Georgia statutes. Judge, so the county's position is that the general tax code applies to all properties, including those in private trusts, unless there is a specific exemption. Mr. Smith, how do you respond to this argument? Accused, Your Honor, while I acknowledge that OCGA 4853 covers general property tax obligations, I maintain that this trust property qualifies as an exception under both constitutional principles and